accepted that they have granted age relaxation in 29/9/2020. This is an extension of the process of recruitment started in 2018. The eligibility is determined on the date of submission of the application in 2018. If they say that relaxation is granted by this, in absence of relaxation, could they have refused anyone to upload his document on the ground that he has become overage because his eligibility has already been determined in 2018? So where is the question of declaring one eligible or ineligible in 2022 or granting him exemption? So the submission is this, that Manu, that is why I
For relaxation to on 22. Yes.
And Manu, that was the reason that I used the term that the whole issue is being confused by saying that this 29/9/2022 exemption, the relaxation in age limit has been granted. So it does not, Manu, even this does not spell out, but assuming for a minute, this 29/9/2022, no relaxation was required because the eligibility has already been determined in 2018.
Okay.
And this is the extension of that.
And some of the other petitioners had appeared in 23.
Yes, 23 months, we were permitted by the court by way of interim order because they were not accepting our forms. Therefore, Malad, we approached this honorable court, we were granted permission to appear, we have appeared in examination. Now, the persons who had appeared in 2018, Malad, one set is that those who have appeared in 2020.
Yes.
The another set of candidates who appeared in 2018. Assuming they paid for any reason, they did not come in merit. There were various reasons. EWS relaxation was granted subsequently. Therefore, some of them could not appear earlier. But assuming that all of them have paid in the first recruitment,
In the 18 recruitment.
in 18 recruitment, they also did not get any age relaxation because they appeared in 2018 examination.
They appeared again.
They appeared in 2023.
23.
Yes, some of them have not appeared because the 18 has got now eligibility, validity has been given for lifelong.
Yes.
Therefore, they will appear in selection test on the basis of the 2018 eligibility.
So there are 3 or 4 categories of petitioners.
There are in fact two factors.
Only 2. One who had appeared in 2018 and passed. One who had appeared in 2018 but failed. And the third is one who appeared in 2023.
That was when 2021 was not a, it was not a 2021.
2021, what happened in 21?
21 was not a eligibility examination.
You've not said anything about 21. Where is that 21? That is a primary teacher. But you said this pertains to only Uच्च माध्यमिक शिक्षक. Primary भी है इसमें.
सर इसमें मेन बात ऑनर्सनल फीस बालाजी सर इसमें मेन बात ये है the only issue
Let him complete.
the only issue before your lordship whether one
You please tell us about the primary teacher also. We have understood your point.
but
Primary teacher क्या है?
one primary teachers were also because ये अगर
They appeared when? 2020.
qualified my lord
No, appeared in what? 18.
He was only back in the year 2018. There are only twice TET has been conducted by the state government. One in the 2018 and second one is 2021.
There should be no dispute on these facts.
2020 primary teacher.
as far as my knowledge goes, there was one TET between 2018 to 2023. It was only 18. My friend is confusing with that.
Yeah.
Page number इसी का जो document है. तो page number
But ये BC in 2020, one TET was conducted for primary separate. So, that also covers this aspect because that was also prior to 2022. So that relaxation could not have been available in the even 2020 examination. So one of the whole issue which comes before your lordship is that.
So the petitioner in that Mr. Nayar's petition appeared and passed. You made some synopsis chart or something of this? No.
These matters were linked on the basis of statement given by the government advocate before the land and bench were not. That basis, all of these matters were linked.
these issues are
Single bench, Gwalior,
that case has been relied by the division bench.
and upheld by the division bench.
That was not of the facts were not correctly clear.
Only which has to be considered by this honorable board whether this is the first advertisement or not.
Yes, yes.
Yes. The advertisement issued.
Yeah.
15, mention it.
Yes, I have mentioned.
So in this advertisement of 19/10/22, there's a reference that for primary teachers, TET was held in 20. So in that 20.
But 20 also or 22, the relaxation would not have been available even in 20 also.
But when this advertisement was issued, प्राथमिक शिक्षकों के नियोजन हेतु विज्ञापन, ये रिलैक्सेशन एग्जीक्यूटिव इंस्ट्रक्शंस के बाद इशू हुआ, इसमें दिया इनको?
नहीं, एग्जामिनेशन तो 20 में हो गया ना.
Last date of submission of forms.
Now, 25th January was the last date. The examination
Last date was
25th of January 2020.
25th of January 22.
2020.
Last date of submission was 25th of January
2020. And examination was held somewhere in month of April 2020. So, in any case, my lord, this 22 benefit should not have been available in 2020. So, जो legal issue है सब में एक ही आ जाता है. Ultimately, it comes to the same.
ये 22 के एडवर्टाइजमेंट में इन लोगों ने स्टेट ने आपको रिलैक्सेशन दिया है?
नहीं,
This is what they say in their affidavit.
सर 22 में आप देखें ना सर एडवर्टीजमेंट कहाँ है रिलैक्सेशन और रिलैक्सेशन सर क्यों नहीं सर एक मिनट देखें अगर ये हमको रिलैक्सेशन नहीं देते 22 अगर सर ये हमको 22 में मान लीजिए हमको रिलैक्सेशन नहीं देते 18 में हमारी एलिजिबिलिटी डिसाइड हो गई 18 के आधार पर हमारे अपॉइंटमेंट होने हैं 22 में could they have said that we are over is selection process had started in 2018.
नियम निर्देश प्रक्रिया देती है समझते हैं ऑनलाइन पोर्टल पर
संशोधन के नियम लिए
पोर्टल पर है
संशोधन तब तक तो हो ही नहीं,
ये संशोधन
कोई और संशोधन
और नोटशीट लगाई गई है देने के लिए रिलैक्स और
number of posts which have been created by the state government granting the benefit of that certain number. Certain number.
earlier if TT was only selection process provided. The advertisement for TT will decide at later point to decide the eligibility. But in this, I don't think they must have given the relaxation.
Yeah.
Yeah.
First advertisement नहीं है. Advertisement होना ही declined by the subscription was a once only.
For the 2018 TT
All once only.
हाँ.
GOT का जो surrender है उसमें तो एक relaxation first time. But is treating these two as first time. As per them, these are all continuing the exams. So these exams, these are done. Cannot be considered as first time. Second, so started in 2020, that should be treated as like this is the only.
All right, so this, as per the state, this primary teachers were given this relaxation in this advertisement. Where is that?
The chart is there, but they are the number 10
No, the subsequent advertisement कब हुआ है petition?
subsequent
After the rules are amended. कब हुआ?
That is one annexure 3. That is annexure 8.
Date is?
That is for state 8.
18/5/23
उस पे हम मांग रहे हैं उसी में कम मांग रहे हैं.
तो इसमें ये जो 18/5/23 is for the selection test under the amended rules or TET. It is for TET.
after the amended rules, as per the amended rules.
Is it an advertisement calling people to appear in the TET or in the selection test under the amended rules?
Selection test under the amended.
Selection test. People who have already passed TET.
Yes, they have top में लिखा था annexure 3 top में. Selection test.
Also been held in the year 2020 also. That is for उच्च माध्यमिक.
So this is advertisement for selection test.
जी.
अब ये सर ये दिखा रहे हैं कि इससे पहले कौन सा एडवर्टीजमेंट निकला है सिलेक्शन टेस्ट का. इतना बता दो सर कि इससे पहले कोई सिलेक्शन टेस्ट का निकला है. तो फर्स्ट होता है
तो है.
Only advertisement is mentioned in this article.
उच्च शिक्षा और की बेस पर ऊपर कम तो सब बिनाइन में
Will be found.
वर्किंग के बेस पे 20 के बेस पे इसमें हम सिलेक्शन नहीं दिया है रिलैक्सेशन
Relaxation given.
टीचर से उठाकर निकला 1910 पर निकला.
But this only for uploading of documents. ये selection test का नहीं.
At that time, therefore, the only before this came that
Came later. When you
process was only on the basis of TMT. Because of the COVID period, these.
Thereafter, it seems they did not appoint anyone. This is of that select list which they must have prepared. It's my-
1910 से और इस तरह के 29/9 दो थे तो अपॉइंटमेंट किया ना
इसमें अपॉइंटमेंट हुआ है कुछ? Pursuant to advertisements.
See, ultimately, yeah, premier we have given details of the number of posts which have been built up by the state government, with granting the benefit of this. We are the page number. Along with the additional return.
और नीचे इसका
हाँ.
नीचे रिलैक्सेशन
Just after the note sheet. शिक्षण सप्लाई 150 स्कूल शिक्षा विभाग जनजाति कार्य विभाग 1325 कुल आदेश 40,000 माध्यमिक शिक्षक 5,000 जनजाति कार्य विभाग 28,000
तो इसमें ये लोग पास नहीं हो पाए.
These are the
इसमें they were not appointed.
these are the numbers of
No, petitioners were not appointed.
petitioners who have been granted. This is the document in which we have already granted the benefits of the state government.
So these are people who gave appointment, who had appeared earlier where in TET of 18.
2018.
18. So then why did you deny them?
That was only a one-time campaign by the state government looking to specifically to the COVID pandemic situation. To the candidates who could not participate in the selection process and they have crossed their upper age limit.
ये कैसे ये arguments are acceptable?
So this 18, what happened to the people who passed TET 18? Did you appoint them subsequently?
They have been granted benefit part the appointment has also been handed over to them.
By giving the relaxation in higher age. Why was that not given to them? Why is it not given to them, petitioners? They also belong to the 18 TET. Participated when? In which?
वो जो 2018 2018 not participated in this advertisement.
No. In which, when you say they participated in which advertisement, which recruitment?
This
No, not this, please.
this one.
Tell the date.
This is dated 29/9/2020.
29/9/22.
Copy of the advertisement with that page number 7 along with the distributor. Those who have uploaded their documents in pursuant to this advertisement. The merit list has been prepared by the state government and as per the in accordance to the merit list that we have granted.
So, but this was not the second advertisement. It was the same people called for uploading.
Yes, madam.
How do you call this a second advertisement?
Second advertisement is election people which is being challenged in this petition, saying that this is the first advertisement.
That is
That is what we
18/5/23. 18/5/23. That was under the amended rules.
Since the TET could not be conducted by the state government, madam, and in the meanwhile, by the amendment dated 26th of July 2022, validity of the TET has been enhanced to 5 years. Therefore, the validity of the
TET is for life now.
Yeah, after the amendment, madam, now it has been made for
It was made 2 to 5 and then for life.
2 to 3, thereafter 5.
Hmm.
First, it has been extended to enhanced to 2 to 3 years. Thereafter, wide amendment dated 26th of July 2022. The rules, sub-rule 2 of Rule 11 has been amended and the 3 years words is substituted from 5 years. 5 years validity of.
All right, so let us now stick to 29/9/22. This advertisement. Please open that. पढ़िए उसको।
लोक शिक्षण संचालनालय उच्च माध्यमिक शिक्षकों एवं माध्यमिक शिक्षकों के नियोजन हेतु विज्ञापन प्रोफेशनल एग्जामिनेशन बोर्ड मध्य प्रदेश भोपाल के द्वारा आयोजित उच्च माध्यमिक शिक्षक एवं माध्यमिक शिक्षक पात्रता परीक्षा 2018 में हर पाए गए अभ्यर्थियों से स्कूल शिक्षा विभाग के अंतर्गत रिक्त पदों की पूर्ति की जाएगी। रिक्तियों हेतु ऑनलाइन भर्ती की प्रक्रिया उच्च माध्यमिक शिक्षक हेतु दिनांक 30/9/2022 से तथा माध्यमिक शिक्षक हेतु 6/10/2022 से आरंभ की जा रही है। इसके तहत अभ्यर्थी एमपी ऑनलाइन पोर्टल निर्णय पर उच्च माध्यमिक शिक्षक हेतु दिनांक 30/9/2022 को अपराह्न 2 बजे से 10/10/2022 तक तथा माध्यमिक शिक्षक पद शिक्षक हेतु 6/10/2022 से 16/10/2022 तक प्रोफाइल पंजीयन कर दस्तावेज अपलोड कर सकेंगे। दिशा निर्देश रिक्तियां एवं आरक्षण इत्यादि संबंधित विस्तृत निर्देश से एमपी ऑनलाइन पोर्टल पर शीघ्र प्रदर्शित।
So this is in continuation of that 2018. So how do you call this a new advertisement?
Permission, if I may clarify.
The rules at that point of time also did not provide for any other recruitment test or selection test besides TT. So this is actually counseling.
Yes.
You are calling them for counseling.
This is the recruitment process.
How do you call this recruitment? By what stretch of imagination you call this a fresh recruitment? Well, the rules got amended in December 22.
Yeah.
That was 3 months after this. So then at this stage, how could we have deprived them? And the circular had come into being then, by then. That was 18 September. How do we deprive them of the relaxation benefit?
Benefit of the circular has
This was granted.
Just prior to this advertisement, page 6. This is the type of you have an extra one.
So they could not be appointed because of some other reason.
They did not participate in the 2018.
They did not upload their documents.
Yeah, all the people who have participated in 2018, they did not upload their documents for verification and which were the requirement of this advertisement. Therefore, they have not been granted.
No, but we are presuming that they participated in this. They did not fill up. They did not fill up and upload their documents.
Thereafter, we have granted the benefit of COVID survey. The number of posts which have been given by the state government, granting the benefit of that circular.
नहीं, आपने अपने जवाब में कहा है कि you have given the benefit of age relaxation at this point of time, 29/9/22.
Paragraph 5 paragraph 3 of this.
So that means, despite giving age relaxation, why were they not appointed? Because they had passed the TET. There is no other selection test to pass.
They might not have uploaded the documents.
You said that.
I haven't said that. This is the only.
Whether they have said it, they uploaded pursuant to this.
No, they have also.
They have not said it.
We don't need to call for counseling, we went to counseling. Our documents were checked, because they said that you're over it, therefore we'll not give you a call. That is what we have stated, if my pen is kind enough to read.
Where is this in the return? This must be their stand in the return. What we are seeing is AR2. AR2 के बारे में आपने क्या कहा है?
Paragraph 4.
Right?
Paragraph 3. That the answering respondents most respectfully submits that the recruitment rule of 2018 Multiple School Education Service Teaching Cadre and Service Condition of 2018 came into force while Gazette notification dated 30/7/2018.
नहीं कहाँ पढ़ रहे हैं आप? पैरा 3 में तो एडिशनल रिटर्न पैरा 3 हाँ पढ़ी.
Respondents most respectfully submit that the recruitment rules of 2018 came into force while Gazette notification dated 30/7/2018. The teacher eligibility examination shall be conducted for recruitment of the teachers in prescribed manner. The procedure for selection, appointment rule, direct recruitment has been specifically mentioned in Rule 11 of 2018, wherein Rule 11 sub-rule 2 specifically mentions about the recruitment of teachers which shall be conducted on the basis of teacher eligibility examination, and the same shall be conducted by the agency designated by the government. The rule has been repeated in the last paragraph. In view of the said rule, it is crystal clear that and brought to the kind of attention of the honorable court that the recruitment as mentioned in the paragraph 5 of the return which has taken place after the circular of state government granting relaxation of 3 years due to COVID pandemic has been finalized, and the benefit of the said circular has already been given to the candidates participating in the selection process as per their qualification and qualified marks in teacher eligibility examination. Thereafter, in paragraph 4(1), that it is further submitted that the answering respondents in its return para 5 has mentioned that despite that the respondents have given the age relaxation of 2 years in compliance of the instructions of 18/2022 in the first advertisement for the Uch Madhyamik Shikshak and Madhyamik Shikshak as per advertisement dated 29/9/2022, and for Prathamik Shikshak as per advertisement dated 19/10/2022. It is pertinent to mention here that that for giving the aforesaid relaxation in light of the instructions of the 18/2022, approval has also been taken by the higher authority in the note sheet. Copy of note sheet is filed here. Thereafter, the copy is after that, after taking the approval of the authority, the advertisement has been issued and the same has been duly published in the newspapers. Copy of the relevant extract of the newspapers are filed here. And which are ARP.
What happened to them? In that advertisement which you say is second recruitment. ये कहाँ है आपने? You said that benefit of age relaxation given. What happened to the petitioners who are before the court? A context. Petition में बोला है. Petition में भी नहीं बोला है. That they uploaded.
No, they are simply claiming the benefit of this COVID relaxation.
First petition में कहाँ है बताइए? Dr. Amol Soli. Where is it mentioned?
Participated and not selected.
Tell us, where is that 29/9/22 referred in this petition?
29(9) annexure P5.
P5.
60 annexure P5. That is referred in paragraph 5.6.
हाँ पढ़ी.
By placing reliance on the circular issued by the General Administration Department for upper age limit, the respondents have reviewed the circular dated 18/9/2022 issued by the General Administration Department of the state government. It provided for grant of 3 years relaxation in the upper age limit up to December 2023. First advertisement in view of the fact that the regular recruitment examination could not been held in the state for last 3 years due to COVID-19. Copy of the swell.
GTA was
सर इसमें मैं क्लैरिफाई कर दूं थोड़ा सा. ये जो सर ये जो कैंडिडेट्स, दिस एडवर्टीजमेंट ऑफ 2023 इज इशूड फॉर सिलेक्शन एग्जाम्स. 23 advertisement.
No, we are not on 23 right now. We are on
18.
No, we are on 29/9/22.
22 आप देखें सर, can it be said to be an advertisement for recruitment? Well, that,
No.
Manoj rightly pointed out, Manoj,
You were required to upload your documents. So did you do it?
we did not, we were not the candidates.
Because you are eligible. They say that all those people who have passed the 2018 TET are called upon to upload their documents. So where is that averment that you uploaded the document?
We were not eligible. We did not appear in 2018. Yes. We did not,
18 you did not appear.
no. मैं सर ये ना इसीलिए क्लियर करना चाह रहा था, आप इसको देखें सर 2000 ये इनका टोटल
मतलब कुछ अपीयर हुए हैं, कुछ नहीं हुए।
सर इनका कहना यह है कि ये 29/9 का हमने, आप इसको देखें सर, आपने एक सवाल इनसे पूछा था, उसका जवाब इन्होंने नहीं दिया। 29/9/2022 का जो इनका एडवर्टीजमेंट है, इज इट अ फ्रेश रिक्रूटमेंट?
No, it's not an advertisement.
So when it is not that, then it is an extension of 2018.
Yes, yes.
Now, if it is an extension of 2018, in 2018, benefit of circular of September 2022 would not have been available.
Hmm.
So where is the question of that? For the second time we are asking this, because in 2018 it was not available.
Hmm.
This is an extension of 2018. So it means that the first recruitment which was undertaken in 2023, selection test, that was the first advertisement. ये हमारा टोटल केस है। हमारा टोटल केस ये है कि 23 में आपने पहला एडवर्टीजमेंट निकाला, उसमें हम एक रिलैक्सेशन मांग रहे हैं आप, irrespective of the fact whether we appeared in 2018 or we appeared in 2023. The first advertisement, they are only catching, they are saying.
So what about state council? What about those people who did not appear in this 2018 TET, but are now appearing for the first time in 2023 TET?
The benefit is not available to them, not the.
Why not?
Because that is only one-time relaxation with this, the circular itself specifying that.
So this was the second chance. What was the first chance?
First chance for 2000. That treatment dated connection, we are free one. Dated September 22.
September 22 is not an advertisement. It only calls upon the people who have already participated in the recruitment process in 2018 to upload the documents. It's a kind of a counseling.
It was in the process to be unamended rules.
Right.
The amendment have taken place in the month of December 2022, where the selection process has first been introduced by the state government.
Yes.
Prior to that, my lord, the only requirement for appointment.
So how can the amendment apply to them? The recruitment process had begun at the time when the recruitment came. It will never apply to them. You can't change the rules of the game when the game has begun. No, you can change, but it will not apply to the game which has begun.
Only a point of time when we do speaking work formulated manner. And TET, the validity of TET
Yes,
was
yes.
only for certain period.
Yes.
Thereafter, it has been enhanced to 3 years. Thereafter, it has been enhanced to 5 years. And now for a lifetime. Therefore, the persons who have participated in the year 2018 ballot initial as per their qualification, we have prepared the merit list and have granted the benefit of this second amount. This is the
Well, the confusion is arising because some appeared, some did not appear, some appeared later.
That would be immaterial.
What had happened in 2018 TET, my lord, at that time when the TET was conducted, my lord, no one was recruited, no recruitment took place. It was only an eligibility test. So the first recruitment which took place, my lord, it was only in 2022. So, my lord, what my senior is saying that it cannot be treated to be a recruitment in advertisement, my lord, that's incorrect. Why I say so is
Well, the recruitment was over by holding TET.
no money, no money. With due respect,
Obviously, that.
TET is only to determine the eligibility, my lord.
The advertisement and procedure for appointment shall be specified by an executive order. So that is what we asked. Where is that 11/8 executive order issued by the government?
That will point out, my lord. My lord, at that 11 point of time, prior to 23 amendment, the recruitment was done only on the basis of the score of TET.
Yes.
So that is for the first time the recruitment took place in 2022, whereby the age relaxation was granted to all the candidates. This is what our इसमें ऐसा कहीं नहीं लिखा है।
Let him complete, let him complete.
सर ये प्रोफेशनल एग्जामिनेशन बोर्ड वाले का कोई रोल नहीं है।
Let him complete.
Submission of my senior may not make such.
No,
My lord, I'm addressing the.
I'm telling you.
Make such statement.
Let him complete. He is only assisting the court, that's
Sir,
all.
what he is saying, Manoj, please, at my only submission, Manoj, he may make his submission, I'm not saying. What he is saying, Manoj, please see, ये rules में देखें सर, determination of age का किस दिन हो? Age determination is done on the date the recruitment process has begun. On the 1st January of that year, on which the Manoj recruitment process has begun. This recruitment process has begun in 2018. They are saying.
That is why I asked the first question to all of you. 11/8 में executive instructions कहाँ है?
They did not issue any executive instructions.
Not issued.
They said that that the appointment will be made on the basis of the merit list prepared on the basis of examination 2018, eligibility examination 2018.
Where is that?
But this is admitted position. They did not issue any instruction. It is admitted position. They themselves are saying. They themselves are saying that appointments were made on the basis of the eligibility examination.
Select teams will be prepared based on marks. CTET. CTET is eligibility. That's it.
For a moment, my lord, may kindly see the here
percent.
R for 11.
Then that recruitment process. Rules don't provide for anything. Executive instruction state is not telling us what is the recruitment process.
R4 is the.
Please read 11/8 of the unamended rules. So please, what was the procedure prescribed by you?
The instruction, the amended instructions. Section R4, page 19.
R4 is what? So that was after the amendment.
Lecture year. Lecture R4 19. This is the instruction showing the granting of benefit of that curriculum. Paragraph. मध्य प्रदेश राज्य स्कूल शिक्षा सेवा शैक्षणिक संवर्ष सेवा एवं शर्तें भर्ती सेवा शर्तें एवं भर्ती नियम 2018 इस नियम में समय समय पर किए गए संशोधन इससे आगे भर्ती नियम 2018 किया जाएगा। मैं उल्लेखित प्रावधान तथा समय समय पर जारी निर्देशों के अंतर्गत प्रोफेशनल एग्जामिनेशन बोर्ड मध्य प्रदेश भोपाल के द्वारा आयोजित माध्यमिक शिक्षा पात्रता परीक्षा 2018 में निर्धारित प्रतिशत के साथ उत्तीर्ण अभ्यर्थियों के से स्कूल शिक्षा विभाग में उच्च माध्यमिक शिक्षकों सीधी भर्ती के रिक्त पदों की भर्ती हेतु नियुक्ति प्रक्रिया आरंभ की गई है। वर्ष 2018 की पात्रता परीक्षा में अर्हता अर्जित करने वाले ऐसे अभ्यर्थी जिनकी दिसंबर 2019 के विज्ञापन के आधार पर स्कूल शिक्षा विभाग में अभी तक नियुक्ति नहीं हुई है अथवा नियुक्ति उपरांत पदभार ग्रहण नहीं किया गया, वे इस नियुक्ति प्रक्रिया में भाग ले सकेंगे। यह प्रक्रिया मध्य प्रदेश शासन के पत्र दिनांक 29/9/2022 के आधार पर की जाएगी। 29/9/2022 is the advertisement have been published in the paper which is Annexure R3. शैक्षणिक एवं व्यवसायिक अहर्ता। Thereafter, this clause 4 mentions about the.
So the only prakriya, as per you, the only prakriya is given in 29/9/20, which is uploading of documents. Pursuant to TET.
The recruitment process for which have been initiated by granting the benefit of 3 years age relaxation. Thereafter, this clause.
No, so that means this, you have no other separate instructions issued under 11/8 of the unamended rules.
So these are the instructions for which have been.
No, this is issued after the amendment.
ये ऊपर इसमें लिखा हुआ है उच्च माध्यमिक शिक्षा अनुयोजन वर्ष 2022। इसमें ये बात का रेफरेंस दे रहा है कि 29/9/2022 के आधार पर
इसमें सभी को शामिल किया है।
जी, इसमें नीचे तक क्लॉज 4 में देख लीजिए the benefit of age, अधिकतम आयु सीमा 43, 3 years, 40 plus 3. अतिथि शिक्षक जिनके द्वारा न्यूनतम 3 शिक्षक न्यूनतम 30, this is 49, this is the basic ages, basic upper age limit is 49, 52 has been. Thereafter, महिला आवेदक हमारे अनारक्षित वर्ग 48, 57 और 48
ये इस पे 3 साल का रिलैक्सेशन दिया गया।
रिलैक्सेशन जोड़ करके
उसमें ये कहीं लिखा नहीं, मतलब उसमें लिखा
29/2022 में लिखा सर,
उसमें नहीं लिखा, कहीं पर भी लिखा कि
ये इसमें लिखा है जिन ऐसे अभ्यर्थी जिनकी दिसंबर 2019
जी, ये विज्ञापन
क्या ये कौन सा विज्ञापन है?
first advertisement was issued in the year 2018, and the selection in purpose to this advertisement has been stopped due to COVID pandemic. The recruitment could not be done by the state government. Therefore, this circular granting the relaxation of 3 years have been issued by the state government. And the post which could not be filled by this process or not. This the remaining posts have been, because the candidates have been granted benefit of this relaxation of 2 years. दिसंबर 19 में शुरू हुआ, मार्च 20 में से कोविड
So the recruitment process could not be completed till the time the relaxation came into being, right? So the people who are midway in that recruitment process would be given the benefit or not?
They have been given. That's what we have mentioned in
How are petitioners denied?
They might have not been participating.
Where have you said this?
That has not been mentioned. They have not mentioned this ground. Now, Marot, for a moment, Marot, may kindly see the case of Siva Shakawara.
No, we had fixed a case for hearing at 3:30. You've already overutilized your time.
All these issues have been considered by the books.
We'll take it up next week. The arguments are part heard, and matter will be listed for hearing remaining part of the arguments in the next week. You all are not clear on the very basic facts.
actually there is more confusion.
They are creating confusion.
Either there is no averment in the petition,
Along with the.
whether you participated or not, why did you not participate? And then there is no chart prepared, and nobody. There are various categories of petitioners. It's not that all of you belong to the same class. You should separate your, make separate charts.
Not that way. Both matter. Item number in 2020, they might be for primary.
No, we'll take it up next week.
First, we have specifically pleaded. We have uploaded the documents in the form for council event to come. We have uploaded the documents also.
Yes.
Bill number 32, along with connected matters. The Ramakrishna Thakur.
Yes, submit my. Let's submit my. Senior counsel from Delhi.
Yes.
Every time they see question.
Let them submit. No, what is this case about? Application for?
Deferment of the
So you file some application. Where is that?
I was to 420. I copied.
Hmm.
And what we
Like,
the matter. Transfer petition. Along with the petition already pending before the office.
where is the IA is what Guddu Singh? What is the Guddu Singh?
Cancel the appointments made by Oriental State.
Guddu Singh arises out of which order of the, which High Court?
Arises from the, it is registered as a petition. And it arises from the UP.
Fine.
The prayers that we-
Filed in the article 32.
If we are not, the prayer in that petition, that's why I mentioned in paragraph 2 of my application. The first prayer that's for the object. But the prayer is cancel all the appointments in the various states. Basis of that prayer. Considering that what should be stand of the state government is required to be.
Your reply is not there.
Your reply to my petition and copy which I have been supplied. If you see para 2, there is no prayer which is reproduced.
The state's reply is there or not there?
They are on record. They say appointed contest
Petition.
Return file. Oh, this Guddu Singh, where is this petition? Guddu Singh. First, what is challenge there?
But none of us is aware of this, and if there is something from the state of UP was filed in the article 32. Yes, previously, they took shelter of Arnab Ghosh, filed from state of West Bengal.
Let us see what they are. What is this Guddu Singh petition?
All humbleness of my command. Today it is Guddu Singh, tomorrow it may be Rameshwar Singh, previously it was Arnab. They will try to defer it, that it should not be hard at any cost. And this is what it has.
Learned friend should not make this.
And you should have cleared Guddu Singh's prayer. If you move an application,
He's trying to answer petition, because my learned friend should not be from where all this is coming from. Affidavit. It might not affidavit. Please hold your office.
Let us see.
Guddu Singh had filed in the business.
I have supplied. I have supplied the IA filed by Guddu Singh. What is Guddu Singh about? You are not aware of it. You are saying you are not aware of some Supreme Court. We are throwing it to the court, we give it to you, you are disputing that. I'm disputing, there's no real impact that.
No, please dissuade yourself from making any personal remarks.
Something which is completely irrelevant.
No, my request is to both the parties. So that BEd appointees being ousted.
Good house. Consumption.
Some ground. Image this petition, yeah. Here you go. Somebody diploma holders. Do that. Nothing else, you know. So before the degrees complete करने के लिए you have filed it for transfer on what date? 25/1. A2. How many BEd appointees are there who are adversely affected by this judgment of Sharma? How many BEd appointees are there who are adversely affected by the judgment of the Apex Court?
Hello, it's the statement made before the Supreme Court, if I remember,
Large number.
a very large number. On the last date, it was said before the Supreme Court when Arnab Ghosh matter had come up. And at that time, be that as it may, the Supreme Court clearly said that where for primary school teachers, the qualification is only D.Ed. There cannot be a B.Ed appointment for the post of primary school teachers. And the court at the time of dismissing Arnab Ghosh also observed that while B.Ed teachers can be appointed for the secondary education as well as for colleges and other levels, the D.Ed qualification is limited only for the primary school and none other. Now, my lords, in that context, if my lords will look at two applications that were filed before the Supreme Court, the prayer was identical as it's today. If I can just show you, to allow B.Ed people who had participated in exams, etc., prior to Divesh Sharma judgment. And in both those applications, the Supreme Court dismissed the applications or dismissed the writ petitions as the case was. I can just show, my lords, 2 pages of that.
Yes.
Yes, my lords, yesterday we tried to give you that compilation of those various cases. And in that compilation, if just coming to this aspect itself, that this was the relief before the Supreme Court post Devesh Sharma, if my lords may first take page number 16 of that compilation. This, my lords, is the compilation, and in that at page 16 is that application for modification, clarification. We have put only the prayer portion, but filed in the case of Arnab Ghosh. At page 17, my lords will find the prayer that was made before the Supreme Court. Do my lords have it?
Violation of judgments.
My lords, it's a compilation of orders passed by the Supreme Court from time to time, post Arnab Sharma, post Devesh.
No, the entire petition may be seen, my lords, because the major difference will be they are not
Miss,
appointed,
I am sure,
unlike in this case.
my lords, I
They
thought
were
we were
still
on a
not
VC
appointed.
and I thought we were on a VC, and I also
Yeah.
thought that we do not interject and we have always an opportunity, which I'm sure my lords will hear the other side. Now, please see this here.
Page 17.
Yes, my lords, the prayer in Arnab Ghosh is at page 17.
Yes.
To modify, clarify that any recruitment prior to judgment dated 11/8/2023 passed by this honorable court in civil appeal, that is Devesh, shall not be interrupted. And
I don't think we are on the same page.
my lords, do you have a compilation in which it is the head note is this?
It contains main prayer.
Yes, it contains only the prayer, because my lords, it would have become.
Is it a printed page 8 or handwritten page 17?
My lords, does it read as a counsel for the applicant Neha Rathi, and it has a prayer, and the previous page of that is the covering page of application for modification, clarification.
Yes.
My lords have that. I hope we have the same page, my lords.
Yes.
So if my lords may just read that prayer with me, and I will take you to the order immediately.
Yes.
So my lords, the prayer is to modify, clarify that any recruitment process that has commenced prior to judgment dated 11/8/2023 passed by this honorable court in civil appeal so and so, that is the Devesh Sharma, shall not be interrupted and appointment shall continue to be made as per recruitment notifications for recruitment to the post of primary teachers issued prior to judgment dated 11/8/2023. Now, this application with this prayer, that if you have commenced and you're carrying on the appointments, please do not do that because they are prior to the judgment in Devesh Sharma. That's effectively the prayer. This was first originally rejected by the registrar, saying that it is in the nature of review. That is the next order. We are not concerned with that. There was an application then filed before the Honorable Court for setting aside the registrar's order, and my lords will find the order of the Honorable Supreme Court dated 11th of January 2024, dismissing this particular application at page 2930, Arnab Ghosh versus Union of India.
For the very same way, you have to Devesh Sharma. This is another problem from India.
Do my lords have that page of the Supreme Court dismissing that application?
Yes.
Now, my lords, I want to show just one more, which is also very important. Please come immediately thereafter. There was a writ petition under Article 32 filed before the Supreme Court, which is immediately the next page after this order, page number 31.
Yes.
That is called that B.Ed Chhatra Welfare Association versus Union of India. Would my lords just take a look at the prayers made in this writ petition at page number 32? Issue a writ order or direction directing respondents to complete the recruitment process for the post of primary elementary teacher commenced on the basis of NCTE notification dated so-and-so prior to judgment dated 11/8/23 passed in Divesh Sharma. Then issue writ order directing respondent to consider B.Ed candidates as eligible for recruitment to post of primary elementary teachers who enrolled in the B.Ed courses after the NCTE notification and have completed B.Ed before the judgment of 11/8/2023 and who undertake to complete 6-month bridge course in elementary education. My lords, this matter came up on 22nd January, that is just a couple of days back, and the court dismissed this particular petition. It was withdrawn. When at the time when it was being withdrawn, we also pointed out to the court that the advocate filing this petition is the same advocate who had appeared in Arnab Goswami and had suppressed all material facts. The court did not allow them to withdraw that petition. On the contrary, dismissed it. My lords, they dismissed it as withdrawn, but with costs. So the court is extremely clear today that all those persons who have B.Ed qualification are not eligible for the purpose of appointment to the post in primary school teachers. My lords, it's a matter of eligibility today. It's a matter of qualification. It's a matter of a policy of the government, which the Supreme Court has today upheld and quashed the notification by which B.Ed was sought to be included as a qualification for purposes of appointment to the post of primary school teachers. Now, my lords, having said that, I wish to just impress, and of course, my learned colleague, Mr. Vigyan Shah, is there, and he will take you through the judgment passed by the Patna High Court, in which the facts are very, very similar. He has a copy. It will be easier for him being physically present to take you on to that. But I wish to press before you one simple principle. Today, a large number of these appointments have happened, which is after the judgment had been delivered by Rajasthan High Court. The principle here is a notification issued under a central legislation. The central legislation, the NCTE Act, which sets out eligibility criteria and qualifications for appointment of teachers across the country. This is not a legislation, or this is not something which is within the state's domain. It is done under a central legislation. It applies across board, across the country. Once the High Court of Rajasthan quashed that particular notification, my lords, the notification goes out completely. Any appointment made apropos to that particular notification is bad for that reason completely, because then they are not qualified. The Supreme Court did not stay Rajasthan High Court judgment. The Supreme Court merely said subject to the outcome. Now, my lords, today Supreme Court has upheld the quashing by Rajasthan High Court of this particular notification. So to say that even if some appointments have been made, and particularly having been made after the judgment of Rajasthan High Court has come, which has already quashed this particular notification, well, those appointments are clearly bad, because already a central government act, the act under which the notification is being issued, applicable across, has been already quashed. So there cannot be appointments to be made. Today, reliance can't be placed on saying that, well, I have been appointed, but if the appointment has come on a basis of a qualification, first of all, which is not permissible, which is not eligible for the post, and number two, in any case, after the same has been quashed. My lords, I would respectfully submit that these cases are clearly cases today completely Divesh Sharma holds the field. This one or the other ground that has been taken to defer these proceedings by saying that, well, there was first Arnab Ghosh, now some Guddu Singh. Now, Guddu Singh judgment comes out of, if I remember correctly, because I know there's something in Supreme Court, it comes from UP. It relies on a principle of that Maurya, the other judgment, number one. And number two, my lords, this was regarding the cut-off marks. This had nothing to do with this. Therefore, every time when the matter is taken up for hearing, there is one means or the other to deflect that. My lords, I would most respectfully submit that today, in light of Divesh,
All right.
And-
let us,
May
Yes.
may I make a submission?
my
May I make a
lords,
small
can my
submission?
1 minute,
Just
1
to-
minute,
just to-
Miss Mona, 1
yes,
minute,
just-
Miss
just a
Mona.
minute.
I think my colleague Vigyan has that judgment from that Patna High Court. We want to place that. My lords, I'm doing it. He has that physical
All
copy.
right, then.
Please hear that one.
Vipin Kumar.
Just a minute, let us hear Mr. Rupra. Yes.
Lord, my humble request is that my
You
Lord.
are appearing for whom?
I am appearing for those B.Ed candidates, Lord, who are already appointed, Lord, in the month of March 2023. So, Lord.
No, and I fail to understand why is there so much of opposition from the state to hear this matter? Because there is nothing pending in the Supreme Court. The Supreme Court has decided the matter. The review has also been dismissed.
We clarified in 30 seconds.
Don't you think the review has also been dismissed?
My lords, the review has been dismissed.
So that review order, are you disputing that rejection of review?
You place that on record in a compilation, the order. The order has been placed on record.
My Lord, before going into the case, my Lord,
No, the impression that we are getting from the state is that they don't want to argue.
No. That is not.
We can't compel anyone to argue. Unless there is consensus to argue, we can't hear it.
That is not.
Please be very clear on that point.
The state is not saying that we have filed a TP. What is the simple reason? My learned friend is aware of the detailed order. But if I may submit, subject to what my learned friend is going to clarify, the issues, 3 REET petitions. All that order that has been read, Arnab Ghosh and all of September 23, clarifications being filed in disposed of petitions. Supreme Court says, sorry, no, we're not entertaining all this. It's disposed of and disposed of. Fresh REET petitions are. I have this order from 5th of January 24.
Fresh writ petitions filed by B.Ed appointees.
At the Honorable Supreme Court.
So please save us from being.
So, my lords.
That is the request there.
That was discussed.
My lords, may I just point out how my learned friend is incorrect? The last 2 pages that I just showed to you, page number 32, 33 and 34 are fresh writ petitions filed on 6th of January. What is, I think other side must look at this.
Let my learned friend file a reply to the transfer. No, there's no file a reply to transfer.
We can't compel any party who does not wish to argue to argue. That's the
That the learned senior counsel on virtual law from Delhi, he is representing K.C. Nandan.
Yes, KC.
My lord, there is nothing in K.C. Nandan. My lord is not sitting here in a PIL. There are no PILs, not in service matter. So at least Lord K.C. Nandan's counsel should please sit.
I'm sorry, we are
My
representing
lords.
in both the matters. That may not be a correct statement. Mr. Arora is appearing in both the matters. It's not just K.C. Nandan. Please see the compilation, sir.
Things I want to say. First thing, Lord K.C. Nandan's advocate, Lord, they must sit, my lord. There's nothing there, they have no stake here. Second submission, my lord, is I was making at the outset, Lord, that I have made an application to be arrayed as an intervener in the case of K.C. Nandan, which has been allowed by my lord. But Lord, because K.C. Nandan appears to have become infructuous, I have made an application in the case of Vipin Kumar Dwivedi also to be arrayed as a respondent. That idea, my lord, of 17229 may kindly be allowed today.
So why has it become infructuous?
Because
Manoj, who is he to say that it has become infructuous? I am the petitioner. We are the petitioners. Who is he to say that it has become infructuous? If we are pressing for the petition, Manoj.
Court is questioning him on your behalf.
Manoj, I'm so grateful, Manoj.
Matlab, yeah, we will boil all the things, Lord, will boil down to only one case, that is Vipin Kumar Dwivedi.
Where is Vipin Kumar?
Vipin Kumar Dwivedi is before my lord. We will argue Vipin Kumar Dwivedi. My learned friend will tell.
My lords, may please have a look. The relief clause of the case.
My lords, can I say that let the petitioners
Nandan has
address
looked
their
at-
matter?
KC Nandan and John Maladia.
And Rohit.
Yes. My lords, may
As
please-
regards both, it is infructuous.
My lords, that both of them have been appointed. I have decided to those orders. And please see their relief clause. And I will cite law before the lordship. Supreme Court says High Court should not enter into these academic questions. Because these have become academic. Please see the relief. whether because the relief which ultimately they had claimed, they have already got that relief. Now, Manoj will kindly refer to clause 7, paragraph 7.
Today, so petitions are.
No,
First time is started. First of all, petitioners are to be.
First of all, the council in Kesari Nandan, please don't say that anything. Kesari Nandan's case, please be decided first. It is an infructuous petition. Please have a look on paragraph 7 of the relief. Manoj, I'll just read relief clause. Kesari Nandan.
Last time, if I rightly remember, there was some submission made by the council for petition.
Not
And
maybe.
all these appointments are subject to the final.
Yes, but
There is
I-
an order passed by my lords to that effect.
Permit me to clarify
Order
that
passed by my lords
submission.
to that effect.
Kindly permit me to make one submission.
If the petition.
Yes, Lord. I am for the B.Ed candidates. Your lordships have implemented me in Miss Meenakshi Arora's matter, where yesterday submission was made that it is not infructuous because it is subject to the outcome is what the submission was. I'll make it clear, my lord, the writ petition challenges the B.Ed candidates from appearing and getting into the job, and therefore whoever B.Ed is being appointed will be subject to the outcome of the writ petition, my lord. There is no challenge to the appointment of a DLED candidate from being appointed. So what is being sought to be submitted here is that DLED candidate who has submitted to the appointment and joined, is that as if it is his joining as a DLED teacher is subject to the outcome. Lord. This is not
That is an interpretation being given by Ms. Mona. Please see the prayers. We had read the prayers for my lord's convenience last time. Kindly see the prayers. And it is not just Kesari Nandan that we are appearing in. We are also appearing in Vipin. We are appearing in both the matters.
My friend may allow me to complete the sentence, my lord. The writ petitioners are challenging not the challenge is to B.Ed. This is not a public interest litigation, my lord. Once they got accepted the appointment, they cannot pursue with the writ petitions. So therefore, there are other writ petitions which your lordships are anyway going to consider, my lord. This matter.
Manoj, clause 7.1 may kindly see. The relief is already been granted. Manoj, may please see 7.1. It reads, Manoj, that the honorable court may kindly be pleased to impugn the notification dated 28/6/2018 and 30th/5/2018 issued by NCT making amendments under notification dated 23/8/2018 issued by MHRD, Department of School Education, Government of India, whereby candidates possessing qualification of B.Ed have been made eligible.
That Supreme Court has watched.
Now kindly come to the 7.2. The honorable court may kindly be pleased to issue an appropriate writ order direction not to treat the B.Ed candidates as eligible for the post of primary level teacher. This relief has already been granted by the Supreme Court.
What is granted is to continue fresh appointments. Supreme Court has not reseated anybody. Supreme Court has only stopped any fresh appointments and.
No, I'm sorry, that's a wrong statement to make. That's a very wrong statement to make.
I am appearing in
That's
those
a very wrong
matters.
statement to make because we have produced those writ petitions.
The state government is not ready to argue.
Because they don't want to argue because they want to protect a specific. They are not wanting to argue for reasons best known to them. Manoj.
Let John on that by recording that statement.
Also, kindly see every time the state and every opposite council wants adjournment on one ground or another. This adjournment, my lords, is actually in their interest. They want these persons to be continued in violation of Article 21A. Any single day adjournment, my lords, would be at the cost of those children who are being taught now by the different teachers. Supreme Court must be notification of violation of Article 21A. They want to be made party with adjournments day after day on one count or another. My lords, kindly see.
Supreme Court did not take adjournment.
It's a matter for petitioners' arguments.
As far as we are concerned, the judgment is clearly distinguishable on facts, my lord, and also we are very well protected. As far as we are concerned-
Even otherwise, it will take time to be heard.
Yes.
Because it won't take time. My lords may just give us 5 minutes and we'll be done. Just 5 minutes.
Within 10
5 minutes to show that nothing remains now. Just 5 minutes.
I'll not make any submission.
So much of opposition, even on hearing. Imagine what.
Because for obvious reasons, because they are placed. For obvious reasons.
Energy for the transfer. Why should I say my energy? Transfer petition is actually miscarriage of justice where you have moved an application. Kindly tell that to the Supreme Court. Kindly say that to Congress. Good thing comes from state of UP. There was no order. It's a writ petition filed under Article 32.
Because I am appearing in that writ petition, Guddu Singh, there is absolutely no connection. I'm appearing in that matter. For some of the DLED candidates, there is no connection of issue. And my lords would recall that every time there is a new ground coming for adjournment. Why? Because these B.Ed candidates are serving.
Said that Arnab Ghosh if not decided, your lordship will deal it on merit. Arnab Ghosh was dismissed. If they were heard, Arnab Ghosh was dismissed. The lodgement order says that the consequences were to follow. No person who was appointed cannot be saved. Then the man of silence that in Arnab Ghosh.
Incorrect statement.
Absolutely incorrect. I'm trying to counter it on respondent being said that. It is clear that both applications intend to seek for recall of the review of the order passed by this honorable court in the guise of filing the present instance applications. The prayer made in these applications itself would make it clear that applicants intend to seek for re-hearing of the matter on merits after reviewing the order dated 11/2023, which is confirmed under law.
But as far as we are concerned,
All right, please start your argument.
Very well, my lord. So grateful.
We'll deal with the objection. We'll deal with the objection. We will deal with the objection. We will record that you are not cooperating. Yes, please start arguing. Please start.
I'm respecting from this.
Just give me 1 minute.
Your lordship, the kind of government
Before he starts his argument.
I started my argument.
Let him start it.
I started my arguments. I am on page 15. As per your
We will call for your application, whichever is filed is not here with us. No, it's not uploaded. It's not on record. No, we will not see that. We will see the one which is filed. We'll call it whenever it comes, we will see. And then at least start arguing.
Please see page 16 first, the application that was filed by Arnab Ghosh. Please see 16 for a minute, and then we can come to 18.
If you can please wait for a minute. This is page 18 of the compilation which you are having. It's Devesh Sharma versus Union of India.
I'm making a request to the honorable court. To the honorable advocate general also give the arguments of that. You also
Ask him to join in whenever but we can't.
then we'll have to take it up in the next week.
No, I'm sorry. I'm sorry. We reject that prayer. If you want, we can put it down and write. Please start.
Time to come to the compilation.
Please start your argument.
I started my argument. Kindly come to page 18, tab number 3. Now, Mr. Gadial, would you please allow me to make submission? Being a senior counsel, I hope and I request we have to learn from you.
Mr. Counsel, please leave it that to the court. Handle Mr. Gadial.
There is no objection in his argument. I'm only saying that the Kesri Nandan case can be decided first because this has been rendered in first. Let him argue the other matter. I have no objection. No, but this Kesri Nandan case was.
Which case are you arguing?
I'm arguing in Vipin Kumar Devi.
He will argue Vipin Kumar and no.
Where is that? That is WP.
Well, that is second case. That is the next case. First case is Kesri Nandan. And I would like to place some law for your law as far as Nandan is concerned.
But I will not take lordship to the files because there is a compilation.
28.1. 28.1.
Yes, this is 38.1.
No, that is Sakshi Trader.
No.
32. Sorry.
Please list Vipin Kumar is 32.1, writ petition 595 of 23.
595. Vipin Kumar Devi. Somewhere I'll just take your lordship to this compilation. I'll not take your bother your lordship to the files. I'll just be referring to the compilation.
Yeah. 32.1 is Vipin Kumar.
Yes. Now, Madam, if your lordship have this compilation which Madam Meenakshi Arora was referring to, because not to bother with the different compilation, please come to this. And let me take your lordship to the lodgement order at page 18.
Can we show 17 first if you don't mind? 17 is the prayer. The prayer would be important. Please show the prayer. At 17, what was the prayer in Arnab Ghosh?
Which compilation are you
This is this
talking about?
No, this compilation which Madam Meenakshi Arora was referring.
Yeah.
It's just a compilation of orders, Malos, that has been filed for convenience. Orders and prayers. Nothing, no reading has been placed.
Yes.
Now, your lordship.
Yes, please.
Please come to the prayer at page 17. This was the prayer,
17.
page 17, running page 17. This prayer number 8.
In Arnab Ghosh.
Modify or please clarify that any recruitment process that has commenced prior to the judgment in 2023 passed by the Honorable Court in Civil Appeal number 5068 of 2023 shall not be interrupted. The appointment shall continue to be made as per recruitment notifications for recruitment to the post of primary teachers issued prior to the judgment dated 11/2023. So by this prayer, my lords, it is very clear that all those processes which have initiated the appointments being made should continue, and the judgment in itself should have a prospective overruling. The impact is prospective overruling. Now, my lords, what does the government
Not concluded, ma'am. That's like 90.
commenced, concluded, whatever it is supposed to. Now, please don't disturb in between. I'm making my submission. You may counter it. Now, my lords, can you come to the next page? The third paragraph. The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court was challenged.
Where are you reading?
This is page
Page
18.
18.
Yes.
This is the order dismissing this application.
The judgment dated 25/11/2021 passed by the division bench of the Honorable Rajasthan High Court was challenged with the Honorable Court in Civil Appeal number 5068 of the 2023 and connected appeals. Apart from the said appeals, petitions filed under Article 32 of the Constitution of India, even with the same issue, were also tagged with the appeals. The NCT notification and issue notification dated 28/6/2018 exercising powers under Section 23(1) of the Right to Education Act 2009, making B.Ed degree holders eligible for appointment to the post of primary school teacher class 1 to 5. When the advertisement was issued on 11/1/2021 by the Board of Secondary Education State of Rajasthan, it excluded B.Ed degree holders from the list of eligible candidates, which came to be challenged before the Honorable Rajasthan High Court. The notification dated 28/6/2018 issued by the National Council for Teacher Education came to be quashed by the Honorable Rajasthan High Court, which held B.Ed degree holders to be unqualified for the post of primary school teacher. Thus, the issue that arose before this Honorable Court was whether National Council for Teacher Education was right in including B.Ed degree qualification as an essential qualification for appointment to the post of primary school teacher level 1. After detailed consideration of rival contentions, this Honorable Court was pleased to dismiss the appeals and confirm the judgment passed by Honorable Rajasthan High Court dated 25/11/2021. It is specifically observed that the Honorable Rajasthan High Court has followed the settled legal position and no interference is called for. The said civil appeals have been dismissed in terms of reportable judgment. This Honorable Court, while disposing of the said appeal on 11/8/2023, inter alia has been pleased to pass the following order. What the Rajasthan High Court has stated above, it is a settled legal position. In a recent judgment of this court in state of Manipur versus B. Suraj Kumar Program and others, this position that a statute has been made by competent legislature is valid till is declared unconstitutional by a court has been reiterated. Consequently, the appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28/6/2018 is hereby quashed and set aside. The writ petitions and all pending applications stand disposed of in light of the above order. The present application for modification of the clarifications filed by applicant Mr. Arnab Ghosh. The prayer made is to modify the judgment dated 11/8/2023 passed in civil appeal by clarifying that the appointments to the post of primary school teachers shall be made as per the recruitment notifications issued prior thereto. This may kindly be marked. For the other applicants, Mr. Achinta Dhara and Ms. Tanishta Das, who intend to come on record through impediment, are persons belonging to the state of West Bengal and B.Ed degree holders are aspirants to the post of primary school teachers. They have applied pursuant to notification dated 23/12/2022 issued by West Bengal Education Board, which is subject matter of challenge before the Honorable Kolkata High Court. It is well settled that applicants cannot seek for review or recall or modification of the order passed by this Honorable Court in the guise of filing applications. Deprecating the tendencies of the litigant in prolonging and indulging in endless litigation, this Honorable Court in the matter of Indian Council for Environmental Action versus Union of India, and then I was referring all these judgments.
25 directly. 25 last part.
Is 25.
Yes.
It is clear that the applicants in both applications intend to seek for recall of the review of the order passed by this Honorable Court in the guise of filing the present precedence applications. The prayer made in these applications itself would make it clear that applicant intends to seek for re-hearing of the matter on merits after reviewing the order dated 11/8/2023, which is impermissible under law. This honorable court has been pleased to reiterate the law and confirm the judgment passed by the Honorable Rajasthan High Court, and necessary consequences would follow. This may kindly be marked.
Means appointments made 10 years ago will
Do
also.
not accept what I am submitting, my duty.
They are wasting the valuable time of this honorable court, Lord, saying something which is not written in the order. It means necessary consequences means appointments made.
Let him complete.
The applicant intends to re-agitate the matter by filing miscellaneous application for clarification of the modification which cannot be permitted under law. The other applicants were aspirants to the post of primary school teacher in West Bengal Education Board were not parties, and even according to their application, their challenge is pending before the Honorable Calcutta High Court. The aforesaid principles consistently laid down by the Honorable Court would reveal that no application seeking for review, recall, modification of the order of the judgment maintainable under the same is not envisaged in law. When the said principles are applied to the present application, it is clear that applicants are attempting to re-agitate the issue and obtain indirectly, which could not be obtained directly from this Honorable Court. This is very important, my lords. There are absolutely no reasonable grounds made out to the applicants to entertain these applications. For all these reasons, I refuse to receive the present application, as it does not disclose any reasonable cause for being entertained, and they were dismissed. Now, my lord, this order of lodgement was challenged at page 27. This is what on last occasion respondents referred that the matter is pending with an enough votes. I take your lordship to the last order sheet. Your lordship may now kindly mark this IA number. Please come to the prayer at page 28.
Yes.
Set aside the impugned order dated 22/9/2023 passed by learned registrar judge listing MA diary number 36321 of 2023 and directly learned registrar to register MA diary number this and this. However, this matter was referred to the bench which delivered Devesh Sharma's case at page 29. Justice Anuruddha Bose, Honorable Justice Sudhanshu Dhulia.
The date is important, 11 January.
11th January 2024. On 11th January 2024, after hearing all the parties,
Make this prayer.
Please see the prayer also, please.
it is the IA challenges to logical order. Dear Lords, after hearing them, kindly see at page 30. We are not inclined to entertain this application, the miscellaneous application. Now, my lords, at this juncture, I will wait. Please come to your lordship's order of 4/1/2024 in case Srinandan and other connected petitions. If your lordship come to the 4 January 2024 order,
Yes.
kindly see, my lords, after hearing learned counsel for rival parties and facts which have been brought to the notice of this court, that an application for clarification bearing the MA number 2206 of the 2026 still pending consideration before apex court and is tentatively listed before the bench on 11/1/2024. As per the website of the Supreme Court, it would be appropriate to await the verdict of apex court. Anxiety has been expressed that B.Ed appointees who had filed MA 2206 of the 2023 before apex court may delay the matter by keeping the said MA pending for long. In view of this court deems it appropriate to observe that on the next date of hearing, if no clarification is granted by apex court, then this court may be free to decide the matter on merits. Interim relief may need to continue till next date of hearing, and then the matter will be listed on. So now this very MA, which was in lordships awaited, this was dismissed by the very same bench which delivered the judgment in the case of Devesh Kumar.
My lord, let me explain it.
My arguments do not discuss it.
He has not finished.
My lord, it will help.
No, we can't have arguments piecemeal.
Now, my friend, this was done. The things now which has become very much clear is that the B.Ed candidates who were the beneficiaries of all those advertisements issued prior to 11/8/2023 approached the Honorable Court in a pretext that judgment of Devesh Sharma should be treated to be a matter of prospective overruling. All appointments made, all process initiated, they should terminate in the benefits of the B.Ed candidates being treated eligible till the notification was quashed. Now, manus, that clarification, the lodgement order was dismissed, the application was also dismissed. Now, manus, without wasting a lot of time, please come to the judgment of High Court of Patna, which was seized with the very similar position which your lordships are seized with. Your lordship may kindly come to compilation page 36. And I take your lordships to the page 43.
Yes. Yes.
Please come to Manas the fact from page 6 by 2023 order. The rate petitions, you also got it?
Yes.
The rate petitions agitate the issue of consideration of candidates having B.Ed from any national council for teacher education for appointment as teachers in primary schools holding classes between 1 to 5. The stipulation to entitle B.Ed qualified candidates made applicable for teachers posts in primary schools came by way of a notification issued by NCT on 28 June 2018, which has now been set at naught by the Honorable Supreme Court in Devesh Sharma versus Union of India. The writ petitioners challenged the notification before this court by the apported petitions in the year 2021. In the meanwhile, a similar challenge raised before the Rajasthan High Court was allowed by a judgment dated 25/11/2021, rendered by a division bench of that court. It was said that judgment challenging the SLP which resulted in the decision in Devesh Sharma Supra. In the above writ petitions by order number 3 dated 16/7/2021, a division bench of this court permitted the respondents to carry on with the process of selection and appointment during the pendency of the writ petition, but made it subject to the outcome of the writ petition, and also stipulated that the candidates selected and appointed shall be made aware of the pendency of the writ petition. Exactly the same situation. IA number 1 of 2021 filed on behalf of the interveners who were B.Ed qualified for implement as party respondents in the main writ application was disposed of without allowing the prayer for implement, but reserving liberty to file afresh if the need to arises. However, the applicants were permitted to assist in the matter, and it was also directed that the London Council would be sent a link of the proceedings for online hearing. A further including petition seeking permission to be included as petitioners to support the cause of those qualified with a diploma in elementary education was rejected. But yet another division bench as per order number this and this. Now, your lordship may kindly come to para 6. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out. The lordship are getting para 6.
At page 45.
Please come to para 6, the very same position. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out, none of whom are before the school. However, it has to be noticed that the selection was proceeded with on the basis of the amendments made to the rules of the state in accordance with the modification brought about to the essential qualification by the NCT in the year 2018 by virtue of interim order number 3 referred to above. The division bench had categorically observed in the said interim order that the pendency of the writ petition shall be intimated to the candidates selected and appointed, and they shall not claim any equity since that selections and appointments were directed to be carried out only subject to the outcome of the present writ petition. So, one of the very same position here, we challenge the state rules, we challenge the NCT notification, the lordship passed an interim order that the appointment shall be subject to the outcome of the writ petition, awaiting the Devesh Sharma's final verdict. The interveners who support the cause of B.Ed candidates are before us, and despite the pendency of the writ petitions having been communicated to the appointed candidates as vowed by the government advocate, none except the interveners herein have sought implement. Their cause being adequately educated before this court, there is no scope for any further directions to be issued for implement of the affected parties, who, despite intimation of the pendency of the writ petition and their appointments being subject to the final outcome, have not cared to get themselves implicated here. We proceed with the matter, especially noticing that the issue is no longer res integra going by the decision in Devesh Sharma Supra. Sri Nignath Mauli, London Senior Counsel, however, pointed out that though there is no specific.
All right, we'll continue on the next working day. What's that?
We are. Next week may not be taken, we will take it after that.
Sorry, Milord. Sorry.
There is some urgent matter which has been said. The supplementary list is coming in 2 minutes. For 2 minutes, you can continue.
On Monday, then I'm praying for on Monday time. Because Monday is the next one.
Because if I adjourn your matter, then I will have nothing, no work to do for the next 2 minutes or 5 minutes. Continue for 2-3 minutes till the supplementary list comes.
Milord, we will We will also make our submissions that it can be distinguishable on facts in Devesh Sharma, and MP has its own rules.
Yes,
and
yes, you will get your chance on the next one.
Your Lordship, I kindly now come to that paragraph.
You were where? Para 9?
Para 7, my lords.
7.
7 and 46.
See, regards to Maulik, Rakesh Senior Counsel Order pointed out that though there is no specific express intent as available in the judgment, the fact that the Honorable Supreme Court, while deciding Devesh Sharma Supra, has in the operative portion found fault with the state government for not having permitted the B.Ed candidates to participate in the selection that was notified in the state of Rajasthan. This action of the state was held to be improper since the constitutionality was not being decided at that point of time. This made the decision prospective in nature, and hence the instant selection and appointment carried out prior to the judgment would have to be upheld by this honorable court. So, Manas, there's the very same position that whatever has been done should be saved. Then, Manas, may kindly see. Further garner support for the proposition of prospective overruling, the learned senior counsel placed reliance on Soumya Organics, Kailash Chandra Sharma, all these matters. Reliance is also played on all these. Then your lordship may kindly turn to para 13 at page 49. There, matters the honorable division may start noticing the facts regarding coming out of this notification. We have to notice the notifications from their matters dealing with Ramcharan Maurya, Devesh Sharma, all those judgments. Now your lordship may kindly come. Page 20, para 19, page 55.
Page 50. Right.
Page 55, my lords, page 55.
Sorry, page 58.
Yeah. Yeah.
Para 24. Now the question arises as to whether there is any justification for the argument that the declaration made in Devesh Sharma Supra is prospective in nature. Soumya Organics applied the doctrine of prospective overruling and referred to Golaknath when the parameters of such power were laid down at first employed. It was noted that Golaknath laid down that doctrine of prospective overruling can be invoked only in matters arising under our constitution. It can only be applied by the Honorable Supreme Court, and the scope of the retroactive operation of the law declared by the Honorable Supreme Court superseding its earlier decisions left discretion to itself to be molded in accordance with the justice of the cause or the matter before it. Prospective overruling was found to be a recognition of the principle that the court molds the relief claim to meet the justice of the case. Justice not its logical but in its equitable sense. There is no such express declaration made by the Honorable Supreme Court in Devesh Sharma Supra. His lordship may kindly note this. Much has been argued about the Honorable Supreme Court having noticed that Rajasthan government, when issuing an advertisement, had not included the qualification of B.Ed candidates, especially when they were made eligible as per the statutory notification of the NCT, which was also binding on the Rajasthan government. This impliedly indicates the prospective overruling is the contention raised, which we are unable to accept. The above observation was only in the context of Rajasthan High Court having set aside the notification dated 28/6/2018. In the operative portion of its judgment, had the state government could not have ignored the notification of the NCT while issuing the advertisement. The Rajasthan High Court had clearly stated that since the notification itself was declared illegal, the issue was only of academic value.
We'll take it up on the next one.
My lords, consider recording it as a part heard by the petitioners.
Case stands part heard. Let the case be taken up on Monday. Hearing the remaining part of the
Grateful, my lords, deeply grateful.
application state which has been filed today. Today, IA number so and so shall also be for deferring the hearing of this petition shall be taken up on the next date of it.
Instead of the time of taking up the week after, next week is moved to be all out.
Provided the other side agrees.
Members of the bench, I think, at least for 2 days, at least for 2 days, even the members of the bench. So now marked as a part.
Now memory will fade. After 1 week.
Actual memory.
No.
Only request of time for also aware that they would log in by that time.
Same 3:30.
3:30.
That was taken up on 3 or 2:30.
You make your arguments concise, precise.
This judgment only covers every aspect. That my lord covers every. One indicted person, but my letter will not accede to that. Making it, when my lord take it up, it's marked as a partner now, on 5th or 6th.
If we are opposing any kind of further adjournment,
Argument that has happened, they'll have to, which way the recap, you know, read background of it. They all. Therefore, I'm saying it can be.
grateful, I was deeply grateful.
Lordships are fixing 3:30 minutes.
Never we start. My learned friend has created great confusion. Your I will like to respond first. Then if anything is required, then I just want to clarify that what.
You are an intervener, Mr. Rupra. Interveners only have a right to audience. That is all. You are not the main.
We are respondents.
Well, so we'll hear the main contesting respondent first.
That's why I was simply suggesting in one case. I will intervene.
Your Lordships will hear me, my lord. My impleading has been allowed, not Lordship will hear me after this.
In the case.
My lords have got the gist that why is there being so much of delay that is being caused, my lords. So 29th would be a good date to hear, my lords.
My lord, over the fifth. My lord, in the case of Vipin Kumar Dwivedi, please allow my IA 17229 today.
Because we oppose any application being allowed at this stage.
Similar applications of Mr. Gujral have been allowed. My application may also be allowed, lest I may again face some objection like this.
Because we vehemently oppose any such application.
You are for?
I am for that BEd candidate who has been appointed this election process in March 2023. And this person has become intervener in KC Nandan, but KC Nandan may not reach the argument stage because what objection Mr. Gildial has been taking. So, Lord, my humble submission is that this application of mine to be arrayed as a respondent may kindly today allowed. I'm sure my learned friend will not object to that.
We'll hear you after you can distinguish this Patna High Court's decision.
Not just Patna High Court, but the Uttarakhand High Court has also followed it. So the Uttarakhand High Court has also taken a view similar to Patna High Court.
Let them separate those judgments, Lord. We will distinguish them. We will distinguish.
Final argument is taking place, Lord. IA 17229.
Patna High Court judgment has been tested in the
Not tested, my lords, but a similar writ petition has been filed in the Supreme Court, and that writ petition has been dismissed with costs. With a similar prayer.
Any material.
My lord, I take it up on the fifth.
Please, first,
Partner,
the confusion. Only
not today, not today. Not today, on the next one.
Not completed.
Not what's the
Let
effect
him complete on the next.
Effect of Arnab Ghosh and effect of Guddu. My learned friend has wrongly put before this on the.
You can respond it when you ask.
You will get your chance to argue.
They are now they're misleading people.
They are saying that we are dilating on the data.
Yes. He should have at outside disclose this fact that this judgment is under challenge before the Supreme Court. Let me make my. I'm not take it up on fifth, Maharaj.
No, not on fifth. We'll forget everything. We'll forget everything. Forget everything.
Because the intention of the state seems to be clear in this. 29th will be good, my lords. Grateful, my lords, deeply grateful.
Lordship. Take it up.
My idea stands allowed to do that favor my kindly.
No, not you. It's kept pending. We'll take that up also.
No, they kind enough to allow the same application of Mr. Gildial. So I'll be answering.
We'll recall that order.
My lord.
Lord, I'm here, Lord, I'm here. It's so allow us to replace after the petitions argue.
If my laws are not agreeable for the week after that,
Can be 29th or at best 30th.
Because 29th is good, my lords. Either way, the petitioners will have to conclude. They can argue on 30th if required.
Let it be 30th. Let it be 30th.
take it up on 29. We will complete with 30th.
Because we need at least 20 minutes to complete, so petitioners can complete on 29th.
We'll accede to your request to the extent of 30th, that is all, not beyond that. Tell you.
Lordships are fixing a time, my lord. Lordships are fixing a time. Lordships are fixing a time, my lord.
3:30.
Very well. Very well.
Lordship, we are,
Before that, my application will be considered on 30th.
my respectful submission, Lordship, we are interveners and Lordship ने कहा था कि interveners को भी सुनने का मौका दिया जाएगा. Lordship, हम लोग सब appointees हैं और अब ऑर्डर 11 अगस्त 2023 के ऑर्डर से पहले हमने जो अपनी अपॉइंटमेंट पा चुके हैं लॉर्डशिप भी सुनने का मौका लॉर्डशिप.
आपका इंटरवेंशन का सुनेंगे नेक्स्ट क्वेश्चन.
हाईली ऑब्लाइज लॉर्डशिप.
यस.
Deeply obliged.
3:30. Yes. Who is in this? Srimati Fatima Begum.
Bill number 39. Bill number 39, Sri Ethic Khan.
Respondents are state. 43-1.